Welcome to Court Helicopter Explainer that comes every weekend on Saturday and Sunday for the sole purpose of educating our viewers what is the position of the law. There is what people think, but what is the position of the law? My name is Danstan Omari, and welcome. We are on the second series of the Marriage Act, and we shall be looking at what does the law define marriage to be. We'll differentiate marriage, a valid marriage, from other types of relationships. The first one is cohabitation. When the law talks about cohabitation, this is where two people of opposite sex are living together, behaving in a manner likely to suggest that they are husband and wife. They might be having children. They might stay for 10, 20, 30 years. They live in the same house. They attend funerals together. They attend social functions together. And the general public believes that these people are married. That was the law, and that marriage originally was called the marriage by presumption of a marriage because of long cohabitation. That law, that type of marriage died from 2014 when the Marriage Act came into place. There is no marriage by you staying with somebody for 20 years and you think that person is your wife or that person is your husband. By you having children, that person is not your wife. That person by law is a cohabitee. The second group of relationships that we want to differentiate from marriage are side chicks, where one has a girlfriend who visits. They are called day scholars. They come, they go. Or a boyfriend who visits and stays for some time and goes. It can be a weekend. It can be a Wednesday. Such people are not known by law as a wife or a husband. Those are side chicks or side boys. The third one are concubines. This is a relationship where somebody is legally married, but he has another woman outside who they live and cohabit in a manner to suggest like they are husband and wife. Those concubines are not wives for the definition of the Marriage Act. So because of that, now let me explain what the law defines as a valid marriage. There are 5 known valid marriages. 1, the Christian marriages. This type of marriage is a marriage between 2 practicing Christians. Here, the presiding officer, that is the pastor, the bishop, any religious person who presides this marriage is licensed by the Attorney General, the government of Kenya, to solemnize that marriage. That is a valid marriage. The second type of marriage is what we call the civil marriage. This is a marriage where 2 people go to the office of the registrar of marriages. Offices of the registrar of marriages are kept in the offices of either the sub-county administrators, the DC, the Attorney General's office. In this marriage, this is a civil marriage where the presiding person is a government officer. They are called marriage registrars. They conduct a civil marriage. That one, you are issued with a marriage certificate. The first one also is Christian marriage. You are issued with a marriage certificate. The third type of marriage is the Hindu marriage. This is where the people being married or the people marrying are subscribers of the Hindu marriage customs and tradition of faith. This one, the person presiding over the marriage ceremony under the Hindu law is licensed by the Kenya government to be a registrar for the purpose of that wedding. Those three marriages, the Christian marriage, the civil marriage, and the Hindu marriage, are monogamous. Once you have contracted a marriage under this Christian marriage, the civil marriage, or the Hindu marriage, you cannot again marry another person. That is what is called, you have no capacity in law to contract another marriage. So you, if your boyfriend is a married man with a marriage certificate, if your girlfriend is a married woman with a marriage certificate under civil marriage, Hindu marriage, or Christian marriage, you are wasting your time. You are a side chick, you are a concubine, you are a cohabitee who is a foreigner to the Marriage Act 2014. What I'm saying, you are wasting your time. You are not married. The fourth type of marriage is what is called the Muslim marriage. Here the practitioners have subscribed themselves to the faith of the Muslim marriage. This is a marriage celebrated by the religious leaders of the Muslim faith. These leaders are licensed, the religious leaders of the Muslim faith, the Qadis, the Sheikh, the Sheikh, are licensed by the Kenya government, and they will issue a marriage certificate issued by the Qadi from the Kenya government. That marriage is polygamous. By law of the Qadi's faith, the law is that you have a maximum of 4 wives at any one time. 4 wives at any one time. So it is polygamous. And the last known marriage is the African customary marriage, which is specific to every type of caste of really ethnic community. The Kisis have their way to do their customary marriage. The Kikuyus have their ways of doing their customary marriage. The Taitas have their way of doing their customary marriage. The Luos have their ways of doing their customary marriage. What is critical in customary marriage is that it is potentially polygamous. One can have very many wives. You can have 10 wives. You can have 98 wives. You can have 100 wives. You can have 2 wives. It is polygamous in nature. Those are the 5 types of marriage known in this country. How do you prove that you are married? Section 92 of the Marriage Act demands that all the 5 marriages, one must have a marriage certificate. Those who have been in marriage under African customary law, Section 92, subsection 2 and subsection 3 allowed the existing marriages, and they were recognized under Section 92(1). The existing marriages before the act came into place in 2014. The African customary marriages before 2014 didn't have marriage certificates. The law in section 92, subsection 2 and subsection 3 allowed those marriages that were contracted before 2014 3 years, a grace period of 3 years, so that those people go and they get a marriage certificate. So if your marriage is African customary marriage, the Meru marriage, the Kikuyu marriage, the Kisi marriage, the Nyambene marriage, if you have no marriage certificate, then you are not married. That is the position of the law as it is today. Every marriage must have a marriage certificate. If you are staying with somebody without a marriage certificate and the dowry was paid, remember, dowry under the Marriage Act is a token. It is not alliances to be shown to anybody that this is what was paid and therefore are married. Get it from court helicopter. The only document that you have to show that you are born a Kenyan is a birth certificate. The only document that you show nationality is a national identification card. The only document to show that you are married is a marriage certificate. Whether you are married in the Christian marriage, whether you are married in the Muslim marriage, whether you are married in the African customary marriage, whether you are married in the Hindu marriage, or whether you are married in any other 5 modes I've said. Get it today, being a weekend, Monday morning, walk to those offices, register for your marriage and have a marriage certificate, or else you are not in any marriage known by the Kenyan law that is protected under the Constitution and under the Marriage Act 2014. Thank you from Cotton Helicopter.